heirs property. What is heirs property? So let me give you the legal definition here and explain what it is. So the heirs property was brought into the partition statute somewhat recently. I think it was 2020, something like that. The Florida's version of the Uniform Partition of Heirs Property Act. And what the purpose of this act was to come in and say, if people inherit a property, hence the name Heirs Act, then they should have a chance to purchase the interest of the other owners, co-owners of the property before a partition is granted and the place is forced to be sold. I mean, I don't need to explain too much as to why, is a law or why they wanted to codify that in the Heirs Property Act. Because, yeah, if it's a family that inherited the property, a lot of times family have issues. Maybe you should give the people who really live there or really have sentimental value to the property a chance to buy everyone out, at least give them a chance, right? They don't get a discount or anything like that, but they should at least get a chance before the place is just forced to be sold. So if all of the following are true, it is considered heirs property. So a tenancy in common. So that's what I was talking about at the beginning when I said joint tenancy can come into play. Tenancy in common is real property is held by two or more co-tenants as tenants in common. Joint tenancy, which is what I mentioned earlier, or tenancy by the entirety, not heirs property. So tenancy by entirety, for those who don't know, is just joint with right of survivorships between two spouses. So if it's spousal property that you own together, marital property, not heirs property. No governing agreement is another element here. So there's no binding agreement among the co-tenants that governs partition or waives the application of the uniform. So there's no agreement. They didn't agree that this is not heirs property, essentially. And they didn't agree that they're not going to sell the place or that they will sell the place. There's no agreement, right? Next thing, common ancestries. This is the inheritance requirement. This is the heirs requirement, right? At least one co-tenant acquired title from a relative, whether by intestate succession, that's where someone doesn't have a will. So naturally, by law, their portion, their interest in the property goes to their heirs. By will, so that's not intestate, but they had a will that says little Joey gets my interest in this property when I die. Through multiple generations of inheritance, the statute does not require all co-tenants to inherit, just one. And then the next element, one of the three statutory thresholds is met. So just one of these needs to be met for this element to work. At least one of the following must apply. No recorded conveyance in 20 years. There has been no recorded deed transferring title in the last 20 years. Or family ownership is greater than or equal to 20%. 20% or more of the ownership interests are held by relatives. Or C, 20% of co-tenants are relatives. So any of these can be met. 20% or more of the co-tenants are related to each other. So we just need one out of the three of those and then if the first three, again, which were tenancy in common, no governing agreement, and common ancestry, you have three of those, and then you just need one of the following, which is no recorded conveyance in 20 years, family ownership is greater than or equal to 20%, or 20% of the co-tenants or relatives. If one of those applies and then the first three apply, you've got heirs property. So, boom.
For the latest in case updates, legal tips, news, and politics, make sure to like us on Facebook, follow us on Instagram and our other socials, and above all, subscribe on YouTube to get your dose of excellence on a daily basis.